By coincidence, I just, not more than 5 minutes ago, completed a prenuptial agreement consultation with a couple. And they're getting along just fine. They're not mad at each other. And they're not worried about what's going to happen in the future with each other. They're just making sure now, before they get married, which is soon, that they have an understanding with each other what would happen if, they hope not, things might someday go wrong. And as I think Lori might say it, I say it too. I think a prenuptial is one of the most loving things you can do, even though it can sit wrong with some people saying, gee, I'm writing the agreement how we're not going to divide things later. What's loving about that? It's the same kind of loving as you have when you care for your loved ones and you buy a life insurance policy. You're not playing to die, you're playing to look after the interest should it become necessary. Medical insurance, you're not playing to get sick, but if you do get sick, you've already planned in advance things that will prevent the couple from having a dispute later on that often is unnecessary and undesirable for everybody. Remember that when we're a law firm, we always win. We get paid to go to court. You don't get winning if you give us money to go to court. And even when the outcome's predictable, the only person that's doing well by doing that is the lawyers. So if you want to avoid that, a way in this subject is to put together some document that says what's going to happen should something go wrong that you wouldn't want to see happen. Specifically, and I understood the question, what happens if there's a change in circumstances? Prenuptial agreements are enforceable on the terms that are written into them. While the most usual one says, everything that's mine is mine forevermore. Everything is yours forevermore. It can say other things. I've written agreements that say, the house belongs to me. But if we stay married for 2 more years, I agree that that provision won't apply anymore, and we'll put it into joint names. You can also always change it. It may say that your house is yours alone, but at a later point in time, you may choose to put the person's name on your deed with you. When you do that, that change will go against what the prenuptial agreement says and will be superior to it. It becomes joint because you decided to make it joint. I should point out that separate property at the beginning of the marriage in a prenuptial agreement remains separate, and everything connected to it, like increases in value. A house worth a certain amount of money today becomes more valuable in the future because of market fluctuation, reduction of the mortgage by paying it off. It doesn't change the fact that it remains exempt and the full value remains where it was supposed to be. Ironically, the most common place you find prenuptial agreements being litigated is not in marital cases. It's in estate cases, in wills cases, where the relatives come forward, and now there's a big production about it. And that's why older couples, people in their second or maybe more than second marriage, have children of their own from a prior relationship, want to look out for them, no love lost with their new partner, make prenuptial agreements to protect their previously acquired assets. So they're very good documents for that reason. As long as the document says it's separate, remains separate, and says so, creditors cannot come against the other party's ownership of the property. A house that is the husband's house remains the husband's house. If the wife runs up debt or gets into legal trouble, that cannot come back to haunt the husband because that property was never hers. And that protects the husband even more than it would if there were no prenuptial agreement. It still remains his separate house. As the spouse, it wouldn't be surprising for a creditor to try to come against it anyway. A prenuptial agreement covers everything, or as little of everything as the couple choose. It could cover what happens to real estate, retirement plans, money in the bank, inventions, intellectual property, anything, and support and alimony and the like. You cannot, however, write a prenuptial agreement that eliminates the obligation for child support, because the court thinks that child support is the right of the child, and the parties, the parents, cannot give away, legally or otherwise, that child's rights. And so as a consequence, you don't avoid that liability. Lastly, and probably maybe most important to understand, a prenuptial agreement is enforceable in the future based on today's realities. Just because one of the parties may become more wealthy in the future, or less wealthy as the case may be, doesn't change the enforceability of the agreement. in a kind of a joking way I say it, that when you say, gee, I thought you were a thousandaire. If I had known you'd become a millionaire, I wouldn't have signed it. Well, that doesn't work. That's why when we do it, properly so, parties have to make a full disclosure of their current financial reality. So we always attach an exhibit for each party. What are your assets? What are your liabilities? And both parties sign it. And we also include within the agreement how much does each party make annually. We say they're well fixed otherwise, they can look after themselves, they know what they're doing, and as a consequence, it becomes an enforceable agreement. I've written some very complicated prenuptial agreements that covers all kinds of contingencies. What if this happens? What if that happens? But as a matter of cause, mostly the agreements are pretty straight up, and I can do that. So remember, when you come here, we're going to do what we can to protect your interests and to make sure that your interests don't require further service in the future if possible. After all, it's all about your life, your money, your property. So when it really matters, the choice is simple.